meeting on a weekly basis every Thursday. And I don't think I missed. I know Jill may have missed one, but for the most part, we were, as a group, working very closely with everyone who had a specific desire to know more about the bill and know more about what we were doing. I think we've been very transparent all the way through with the discussions we've had. And I think it's been a good educational process for everybody involved. We came to the end of our work probably in November. We had a proposal as a document prepared that was approved by the study committee. But I let it be known at that point in time that this was not the end, but just the first step of that process. We were looking to come forward, and as we had needs for things that were coming out as the study committee's document to review and consider changing, we were open to doing so. And we've got some today that we're going to be at some point talking about as a proposed amendments to the bill. I don't know that we'll be going forward with a vote on the bill today, but I wanted to at least start the process of our having a full committee hearing on this product. We've had it looked at from past the study committee. I think we've had it also in subcommittee for review, David Ralston subcommittee, and now we're coming before the full committee. And I want to give everybody who has a desire to speak about the bill, please do so, and we will be happy to hear your concerns or address your thoughts about the bill. I would ask that we do this because we have a number of people who are wanting to speak, that we try to limit the comments to specific areas of the bill that you can, that say this is something that we want to talk about, that we feel as a specific issue may need some further looking into or work, or if you have a suggestion, perhaps receive it that way. So with this, with the committee's approval, we'll go forward with the review of the bill. Any comments from anyone on the committee before we start? If not, we will begin with the names as we have them in order. We have Brian Fortner, the solicitor of the Douglas County State Court. Mr. Fortner.
Good morning, Mr. Chairman. My name is Brian Fortner. I'm the solicitor of Douglas County and the president-elect of the Solicitor General's Association of the state of Georgia. We thank you for this opportunity to come speak. If it's okay with the chairman, I would just ask that the prosecutors who are here be allowed to stand up and introduce themselves briefly, go in line if that's okay. Is that okay with the chairman?
I'm fine.
Stan Gunner, District Attorney in Notice Circuit.
Scott Ballard, District Attorney in the Griffin Judicial Circuit.
David McKay, DA in Douglas County.
Marquette Baker, Solicitor General in Tripp County.
Barry Morgan, Solicitor General, Todd County.
Leslie Abernathy, Solicitor General in Forsyth.
Kelly Burke, DA in Houston County.
Denise Cheney, District Attorney for the Judicial Circuit.
Barbara James, Solicitor General of DeKalb County.
Gary Bay, representing Rosanna Sabo, the solicitor from that center.
Pat Head, District Attorney, Powell Judicial Circuit. Ken Wynn, District Attorney, Alcody Judicial Circuit.
Wendy Sloan, District Attorney for DeKalb.
Chuck Fayoff, Solicitor General here. Tommy Floyd, the DA in Nashville.
I'm Gary Moss, DA in Cherokee County.
Danny Porter, DA in Rapp County.
Buzz Franklin, DA, Lookout Mountain Judicial Circuit.
Kermit McNader from the DA in the
Conestoga Judicial Circuit.
Paul Howard, DA in Fort County.
I'm Ashley White, DA in Augusta.
Welcome to all of you.
And just to reiterate what the chairman said, I have been involved in the process since July, and I thank the chairman for allowing us to come together at that time where we were allowed to voice some of our concerns, some of them that we maintain through this day. But I just wanted to try to answer a couple of questions that we repeatedly seem to be asked, why the prosecutors have a problem with this bill. From the beginning of the process, as we were informed, we were told unequivocally there would be no major policy changes to current Georgia law. Now, I, for one, you'll never hear me complain that this is not the federal rules, because I know, as Professor Millich has said, no state has just willy-nilly adopted the federal rules. There are a lot of things that take place in a state that are not necessarily addressed in the federal rules that we had to change, and we did that. I also think that it's possible to make changes to the federal rule structure to allow current Georgia policy to stay in place, but to still give us some consistency. The good thing about the federal rules, in my opinion, probably one of the younger prosecutors here, is that if you look at the federal rules and you want to look at impeachment, you go to the 600s. You want to look at character evidence, you go to the 400s. You want to look at hearsay, you go to the 800s. There's consistency there. Knowing that gives you what you need no matter where you're appearing in what state to look up those rules. But that can take place without changing policy. And I will submit to the board that there has not been one issue that prosecutors have asked for a policy change from current Georgia law. And I think we're one of the few bodies that can say that. If anybody's aware of a policy change that we've asked for, I would ask that we be corrected. But we became a part of this process with the understanding there would not be any major policy changes to Georgia law. And there are a few that we are concerned about that I just want to touch on briefly. And there's no hiding the fact, number one, our major position or concern in the Solicitor General's Association has been the argument over bin of mind and course of conduct. Falls within the character evidence rules in 404B. And in our opinion, similar transactions in DUI cases, that is prior DUI convictions, for those of you who may not have been a part of this discussion so far, they are admissible in the state of Georgia to prove bin of mind and course of conduct. They have been for 25 years. Bin of mind and course of conduct are words that are found in case law that I've found dating back over 40 years. So it's something that's been around a while. It's something that's been tested constitutionally. It's been tested in the courts, and it is allowed and has been allowed for some time. Also within the character rules is a requirement that we provide notice of prior difficulties between parties. Now, I don't know what amendments are being tendered, so I may be speaking to some that are being tendered, and I apologize if it turns out I'm wasting anybody's time. But currently, we're not required to provide notice of difficulties between parties, because if a victim and a defendant have had problems in the past, that's unique to that case, and it needs to be considered for whatever bearing it should have on the evidence, and that's been the rule. Now, it's been said that, well, you'll only be required to give notice of what you know of. But the reality is when you try cases on a daily basis, judges oftentimes, because they're afraid to make an error, will determine that, well, prosecutor, you should have known about it. You should have asked more questions. And I submit that there's no amount of questions you can ask the victim to know every instance of a prior difficulty they've had. And it leaves it in the judge's discretion to refuse to admit that evidence. So that's a major concern that we have. Now, it's been voiced that the reason we changed this particular part of the code section is because we wanted to stay in line with the federal rules. But we removed a provision from the federal rules that requires the defense to request notice of this type of evidence. So it appears inconsistent to us. Are we just saying we're advocating for the federal rules, or are we doing something that's beneficial to the defense? And I'll leave that point alone. Another concern we have is refreshing recollection, 24-6-612. Currently in Georgia, if a witness uses a document or some piece of evidence to refresh their recollection, and it's after the swearing of the jury, the defense has the right to review that. House Bill 24 will extend that period back to really, in our opinion, the beginning of trial, because it says indictment, accusation, or the filing of a similar charging document. A warrant could be considered a similar charging document, and oftentimes in state court we try cases on citations. There are accusations, so that would be the beginning of that process. Also, there's a rule called the rule of completeness. In the federal system, it's called remainder of writings. And House Bill 24 makes that remainder evidence inadmissible if the court determines the probative value of admitting the otherwise inadmissible evidence is substantially outweighed by the danger of unfair prejudice. Normally in the state of Georgia, it's the law that if we offer part of a document, then we waive objection to the rest of the document, and the other side can offer that into evidence so that the jury can understand the entire document, so that they're not misled by part of a document. And House Bill 24 changes that.
What area is that from, Mr. Fortner?
That is 24-106, I believe, Mr. Chairman. But one specific area that I wanted to address was, it's been said routinely that, well, removing bent of mind and course of conduct, you'll still be allowed to get that evidence in anyways. I have 2 points to make about that. Number one, if we would still be allowed to get the evidence anyway, why the vigor in removing bent of mind and course of conduct from the allowable purposes? But number two, we began to do some studying this past week at some other states just to see if that was correct in the area of DUI specifically, because that's what's of major concern to the solicitors. So we sent out an inquiry into states that had adopted the federal rules. So far, we've received a response from 11 states: Texas, California, Delaware, Colorado, Oregon, Oklahoma, South Dakota, Arizona, North Carolina, Iowa, and Pennsylvania. Prosecutors from each one of those states contacted us back and said they either had the federal rule or a character rule that's based on the federal rules of evidence. And all of them said that they cannot get in these DUI similar transactions that we spoke of. Now, what's more interesting in doing our studies, we began to look at some statistics from NHTSA, National Highway Transportation Safety Authority. And we looked at these statistics and we found out that those jurisdictions that are not allowing this similar transaction evidence, Georgia ranks better than each one of those states in regards to the percentage of traffic fatalities that are alcohol related. We are in the lower third of states in the percentage of traffic fatalities that are alcohol related. And we began to look a little further because everybody wants to know, what does alcohol related mean? So we looked at the percentage of total fatalities involving actual alcohol impaired drivers. And once again, Georgia ranked below those states. We had better percentage. There was less percentage of traffic fatalities that were due to impaired drivers in the state of Georgia. Now, I don't think that's an accident. I don't think that's coincidence. I think we have some laws in Georgia that are very aggressive in regards to the prosecution of DUIs. And when we looked at these cases, that's roughly about a fourth of the cases, a fourth of the states that have adopted the federal rules. It becomes clear to us that this evidence that we have gotten in for 25 years is not going to be admissible any longer in the state of Georgia. And that is of a major concern to us. And I appreciate the chairman allowing me the time to speak. And I'll answer any questions.
Thank you. Any questions of Mr. Fortner? No one. Let me just hold your seat, because I want to go over a couple of things. We do have some amendments that may address some of the things, but getting back to the issue of the bin of mine, as we've discussed on this item, this is something that came as a result, of course, of case law developing the provision. We've never had, if I'm correct on this, never had a specific statute talking about it. But do you agree or disagree that what has come as a result of the federal rule on the admissibility of evidence of other crimes, language-wise, is it, to you, broader or more limiting than what we currently have in Georgia as far as statutory language?
As far as statutory language, I think there'd be no argument. I think the federal rule is broader. Once you begin to consider all of the case law, I think you have to look at the Georgia system. Once you begin to consider all of the case law, I think that there are some problems there, because our concern is that if you specifically take out bin of mine and course of conduct, the courts who are going to hear this evidence and decide on the admissibility, they know course of conduct and bin of mine has been around. So when they look and try to determine what the legislature intended to do, by including those other means, we specifically included bin of mine and course of conduct. And I try cases routinely, and I'm telling you, judges will say, well, that's an indicator they did not want to admit similar transactions in DUI cases. That's our big concern, is that it's specifically not included when it has been recognized. But I think the chairman is correct. That language is not included in a statute right now, but I would submit that the Wade case is going up and giving the Supreme Court of Georgia an opportunity to address the bin of mine course of conduct issue at the request, really, of the Court of Appeals. So the courts made this mess. If you consider it one, I don't consider it one, but if you do, the courts have an opportunity to clean it up. I think if that's the right thing, if we were to include this in House Bill 24, which I think we could still do and accomplish the purposes of House Bill 24.
Can you tell me one other state, Mr. Fortner, that has bin of mine as a standard for admissibility of evidence of past crimes?
I cannot tell you another single state, just that Georgia has, and we're one of the better ranking states for DUI fatalities.
Yes, I'm saying no one has ever had that as a part of their
I don't know
statutory
that they
language.
have. I don't know that they have, and I cannot give you one, Mr. Chairman.
Thank you. Thank you, Mr. Fortner. Any other questions of Mr. Fortner?
Thank you.
Thank you for your presentation. Next we have is Leslie Abernathy, solicitor of Forsyth County. Good afternoon.
Good afternoon. Members of the committee, good afternoon. Thank you for this opportunity to speak.
I want to pull that mic over in front of you a little bit so
Yes, sir.
people around the world can hear you now.
Nice. Thank you for reminding me of that. I appreciate it. I would like to speak about two provisions of the bill.
Yes, ma'am.
The first provision is located on page 24, line 755. That is 24-6-653. page 24, line 755.
All right.
That new provision changes current Georgia law. It requires that local sheriff's offices, chiefs of police, and all local law enforcement provide a qualified interpreter to any hearing impaired person who is going to be submitting a statement, being advised of informed rights, that would include implied consent, is being interrogated, or being charged with a crime. Currently, the law requires that law enforcement notify the Department of Human Resources, and that the Department of Human Resources provide that interpreter. This shift in the law and in policy requires an unfunded mandate to be borne by our local law enforcement, and given this budget-driven economy and the budget cuts that have been made in each department, it is a shift that it's going to be very difficult for our local law enforcement. The second provision I would point your attention to is located on page 29, line 923. That is 24-7-706. Again, page 29, line 923. This provision is a shift in Georgia law as well. It specifically allows either party in a case or the judge to move for, and for the court then to appoint an independent expert. This provision has no funding attached to it, and it specifically says in the provision that the cost will be paid as may be provided by law in criminal proceedings. Currently, any experts that are appointed by the court in any indigent case, the fees for those experts are paid either by indigent defense on a statewide basis or locally through our county offices, depending on how each public defender or indigent defense office is set up. This again is an unfunded mandate. We do thousands of DUI cases across the state and thousands of domestic violence cases across the state. And those are two of the biggest areas that you see these days, particularly in state court where I practice, where experts are hired. If we are open this up in this manner, providing this statute that basically brings attention to the ability to get an expert and have the court appoint the expert, and then the court decide where the money is coming from to pay for those experts, we're opening a floodgate again of revenue going out to pay for expenses that are unanticipated by our local indigent defense offices, our local boards of commission, and by our public defender offices. So we're looking at costs that are simply not provided for by law anywhere else other than on that local level. And I don't think people have really noticed that in this bill. And it is going to be, I think, a dramatic impact, because when you codify something like this and give that opportunity there, and then someone defending in a DUI case doesn't ask for a court-appointed expert, then you have ineffective assistance of counsel issues, you have more appeals, and again, with the budget-driven economy that we're in, given the state of things, at least on our county levels, and I know on the state level, our funding for transcripts to fight that appeal, our funding for paper, for just the ink to print those transcripts and to provide what has to be done to fight those appeals is going to be cut, and has been cut. So it really, these are very important cost measures that no one has thought out the implications of those on the county level. So that really truly affects us in state courts dramatically. And I wanted to bring your attention to those two provisions.
Thank you, ma'am. I think when you say we'll have a proposed amendment, which may or may not address your concerns. On the first one, let me ask you about the fact that we're going to have in the statute a means as far as describing the fact that when there's a person who is language challenged, we'll say, should they not have somebody who can, in fact, interpret for them? In fact, we do that now.
Yes, sir, we do.
And we're not saying how that's done. It's just saying there is expected to be by law someone to give an interpretation to someone who is language challenged.
Well, actually, sir, currently Georgia law provides that law enforcement will notify the Department of Human Resources and that they will provide that interpreter. And now this new bill states that the local sheriff's office, law enforcement that is having contact with a hearing impaired person, that they will provide that person. But certainly, I think they should have interpreters.
It doesn't say how they provide it. My point. That's what I'm trying to be
No,
sure
sir.
we're both in the same approach to it. We're merely saying there will be provided. And the fact we're using the
Correct.
Department of Human Resources as that means of providing it, does it not mean we're changing that, or can it continue?
I would expect the department, well, I can't speak for the Department of Human Resources,
Okay.
but that language is specifically taken out of this statute where it is specifically included in the current statute. So, and it shifts that burden because it is omitted in the way it's worded.
All right. Thank you, ma'am. Any further questions of Ms. Abernathy? Now, we thank you for your comments.
Thank you, sir.
Rest of the committee. Next we have is Barry Morgan, the Solicitor of Cobb County. Hey,
Thank you,
Mr. Morgan.
Mr. Chairman. I appreciate the opportunity, and thank
Yes,
you to
sir.
the members of the committee. My issues are more practical from an administrative standpoint at this time. We all know the economic times that we're under. Last Thursday, my county manager called again and asked for another substantial cut to our budget. We're in the middle of our budget year, as well as the state is. We had already cut 5%. He asked for an additional 2.5%, which we met. Changing this code at this time will tremendously affect the economic cost to both the state and the counties in two areas. Number one are appeals. In the late 80s, 5 words in the implied consent statute were changed that allowed for 5 years worth of litigation. We litigated every one of those 5 words. By my estimation, and I will admit it's an estimation, there are over 55,000 words in this document. That is great fodder for appeals. I had to cut another 2.5% of my appellate budget along with everything else over the course of the last couple of days. Secondarily, I sit on the Prosecuting Attorneys Council as chair of the training committee. It takes $125,000 a day to train the prosecutors of the state of Georgia, because we just recently went through a cut where we cut out several days of training, so we know what that cost is. These rules are going to require extensive training, and it's going to take some period of time to do that. Even though I think the provisions come January of 2011, I don't think economically now is the right time to be making substantial changes to the evidence rules, because these people need to be trained properly. The public defenders, the judges, the prosecutors all need to be trained properly on this. It has been said that these rules have been taught for the last 25 years in law school, and that it wouldn't be difficult for someone to catch up. Well, probably more than 25 years ago, I took Latin. I took 2 years of it in high school, and I took several years of it in college. And while I probably knew it well at the time, and I've been using a derivative language for the last 30 or so years, I would need a tremendous refresher course to become proficient in Latin again. I think it's going to be incumbent upon us to make sure that people are properly trained on these rules, so that we don't make the mistakes that will lead to appeals. So I don't think economically this is the right time to do it. I've been authorized to tell all the members of the committee, because many of you may not know. The two associations, the District Attorneys Association of Georgia and the Solicitors Association of Georgia, have both examined these and have both voted that we do oppose the bill as its current form.
Thank you. Any questions of Mr. Morgan?
Thank you, Mr.
Thank you
Chairman.
for your comments. Next we have is Jack Martin, the Georgia Association of Criminal Defense Lawyers.
Thank you,
Martin.
Mr. Chairman and members of the committee. I will try to be brief as well, and we've gone round and round on this, but I did want to address a few issues that have come up over the last few hearings we had about this. One claim was that, well, we've got this huge bill, and I think the last speaker just mentioned that, and somehow or another this hasn't been carefully vetted. There may be some time bombs in here. Well, as Mr. Chairman, as you said, one of the people you asked to be involved in this thing was Chuck Olson, and there's probably no lawyer in the state better versed in the minutia of criminal law. And if anybody could pick a nit, he could. And during that whole process, he reviewed every one of these things, and we made a lot of changes during the study committee process at the suggestion of Chuck Olson about those types of things that might be unknown or unexpected. So I do believe this bill has been carefully vetted, not only during the study committee, which lasted all summer into the fall, of which I was fortunate enough to be a member of the advisory board, but also during the process we've had in the legislature. I don't think there are any time bombs in here that anybody hadn't fleshed out. Secondly, with regard to some of the issues that come up, it seemed to me, just in my experience, having practiced criminal defense law for over 30 years, that they're really just they're non-issues. The business about a judge appointing an expert, that happens so rarely, but a judge has the constitutional authority when due process requires, and there's plenty of authority, case law going all the way back to Ake versus Oklahoma, as to the due process rights to have experts brought into cases where that's necessary. I don't believe that is really a problem. I did note that one of the concerns was about this business about refreshing recollection and whether or not that would allow a defense lawyer to avoid opting into the discovery statute by using that procedure. I noted that there is an amendment that's been proposed that would limit that to the trial. And that seems to be, if that was a concern, I thought it was not really a big concern because very rarely do lawyers not opt in. But if it is a concern, I think that amendment is something that would satisfy any concern they have, and that's all right. With regard to the question of notice with regards to disputes between the parties. Again, I don't think that's a big problem. Generally speaking, we're going to get notice of that. And then the state has a requirement to provide statements of their witnesses during the discovery process. But I see there's an amendment about that. And if that satisfies some lingering concern of the prosecutors from the defense bar, we don't see a problem with that. Actually, during this whole process over the summer and the fall, we were there, and Chuck Olson and the prosecutors were there, and there were a number of occasions, and I think Professor Millage pointed them out in his memo, which he provided the court. There's 7 different occasions when, at the request of the prosecutors, the federal rules were amended to allow for certain concerns they had. So this is not just the federal rules being lumped onto the prosecutors. There are lots of things that were changed in order to alleviate their concerns. I did note 2 things that were really troubling to me in the amendments. One is as to line 582 regarding the cross-examination of a defendant, and I'm working from the substitute, Mr. Speaker.
Right.
Mr. Speaker, Mr. Chairman.
No.
Somebody made that mistake with regard to Chairman Ralston the other day, which was interesting.
Line 631 is
582, which is on page 19.
Which substitute?
LC 293737S. There's an amendment to take out the word substantially. This is Rule 609 of the rules regarding when you can cross-examine a defendant who takes the stand. Georgia law up until when we changed a lot of things back when we had I forget the name of the actual year it was. I guess it was 2005 maybe. When we changed a number, maybe it was a little earlier than that, a number of things. For years, Georgia law, you couldn't cross-examine the defendant with a prior conviction unless the defendant put his character in evidence. That had been established Georgia law for years. And at that time, working with the governor's office, we arranged a compromise on that. We did away with the Georgia law for years where you couldn't cross-examine the defendant unless he put his character in evidence. But we included the word substantially. And the judge had to find that the probative value of admitting this evidence for its impeachment was substantially outweighs its prejudicial effect to the accused. One of the amendments is to take that out. That was part of the compromise that went into that bill at that time. I don't think it's settled Georgia law now. I don't think that word should be taken out pursuant to an amendment.
I guess the thing I look at with words like substantially, how do we define it?
Right.
And what is the amount that finally makes it either substantially or less than substantial?
Well, it's in the eye of the beholder. Lots of words in the law, like what's reasonable, is in the eye of the beholder. All it really says that in this situation, there is a general rule, Rule 403, that any time the probative value is outweighed by the prejudicial effect, there is a general rule of 403 that prohibits that type. This just says in this one situation, because if a defendant, and let's face it, that the fact of a prior conviction is only being admitted here, not for similar transaction purposes, but solely to impeach the witness, that because that is such a powerful piece of evidence which may unfairly prejudice a defendant who has not put his character in evidence, that we ought to make the burden a little higher in this situation of substantially outweighs, so that the the burden is on the prosecution to show why this particular piece of prior conviction should be admitted. I mean, a prior conviction for perjury, false statement, any type of crime of dishonesty or fraud, that's going to come in. The question becomes where it's a crime that really isn't so much a crime that speaks to the truthfulness of the person, but just is intended to tar his character. That shouldn't come in unless it substantially outweighs its prejudicial effect, the probative value substantially. That's a major change that's being offered from what we discussed this, Mr. Chairman, I know you remember, and we weighed it back and forth, and during the study committee we came up with this as the response, because it is what the compromise had been made when we did this some time ago when we changed Georgia law. So that's a concern to me. That's a more important change in the amendments than you might think from a defense lawyer point of view, from a fairness point of view to the defendant. And that's a concern that we have. The second concern is lines 631 through 634. Again, this is, and I will state up front that this is not the federal rule. It is the thorough and sifting cross-examination rule. Georgia law for all proceedings has always had has allowed a lawyer, if a witness takes the stand, to cross-examine that witness regarding any matter which is relevant to the case. It has to be relevant, can't be an irrelevant matter. But that the cross-examination is not limited to matters that were put on in the direct testimony, which is the federal rule. Even though that is a federal rule, I've tried enough federal cases to know that judges don't draw that line too carefully. If it's relevant, they'll generally let you go into it. But this is one of the amendments that I saw is a major change in Georgia law to do away with the thorough and sifting cross-examination rule, which, quite frankly, every Georgia lawyer knows that's the rule and applies it all the time in Georgia courts. So we have a very worrisome concern about that amendment, which is another amendment that's being proposed that I saw among the amendments being proposed. So I just wanted to pinpoint what that amendment's about so that you can give it more thorough consideration, because that's a major change in Georgia law. Let me, and I did want it to be quick.
Well, since there's only one of you and many of them.
Yeah, I was going to ask all the defense lawyers to stand up in the room, but Sarah's not really a lawyer, but she's a friend. We don't have them. Apparently, we don't have enough. My association can't get away from the office as easily as some of these DAs can, but maybe we just don't have enough badges. The 404B, oh, they're all real good friends of mine.
Yes, sir.
404B, which is the one we've been fussing and fuming about, been of mine. And Mr. Chairman, you were absolutely right when you pointed out that no other state has that bent of mine exception. I just wanted to let you just look at the rule group a second. It's on line 228. This is the federal rule. Evidence is at 404B. Evidence of other crimes, wrongs, or actions shall not be admissible to prove the character of a person in order to show action in conformity therewith. That's the rule. Evidence of crimes, wrongs, or acts shall not be admissible to prove the character of a person in order to show action in conformity therewith. So it's an exclusionary rule. It's the basic rule of law is that you shouldn't try a defendant for this crime by tarring him with some other crime or bad act that supposedly he has done. He should be tried only on the evidence of this crime. Then the rule goes on to say, well, however, there are some exceptions. He may, however, be admissible for other purposes. Now, actually, the words including but not limited to were added at the suggestion of Chuck Olson.
Right.
I think the federal rule is such as. So this is a change that was added at the request of the prosecutors to prove motive, opportunity, intent. Those are, classic examples. If someone is accused of a bank robbery and you want to show that the motive is to get money to pay off somebody, you can go into the fact of the payoff, or an insurance fraud, that you burned the house down in order to file a false insurance claim, that's part of your motive. So there's plenty of ways to get in this type of evidence. Identity is a classic one. The signature crime, a serial killer. If you can find fingerprints of a serial killer's type of murder in a particular situation done in a unique way, then that is evidence of his identity as to a similar crime committed in the exact same way. Those are all the ways that it comes in. And in none of those situations is the evidence offered to prove the character of the person in order to show action in conformity therewith. They're limited to a specific purpose. Bent of mind swallows the rule, does it not? If what we mean by bent of mind is somebody has a predisposition to commit a crime because they've committed it before, that is proof of a character of a person in order to show action in conformity therewith. Course of conduct. What a course of conduct is a little bit like what that was intended to deal with is the situation where the person steals a car in order to commit a robbery. The fact that they stole the car and the robbery is all part of the course of conduct, even though they're separate crimes. So that's what that's intended to deal with. It's never been intended to be a situation where we can prove that this person committed this crime because they've committed the crime before. And that is just repugnant to our feelings of fairness. So I don't really understand how bent of mind got into Georgia law. It's just one of those things that snuck in there in the court decision. It's inconsistently applied. You'll find one case saying one thing, another case saying another thing. This is an opportunity, quite frankly, for us to clarify Georgia law. This is an opportunity for us to get in conformity with every other state in the union, including the federal government, on this issue and be clear about the fact that we're not trying people based on their character, but on the facts of the case against them. Allowing this evidence to come in when it is truly relevant to whether or not they committed the crime with which they're charged, not simply to prove that they are a bad person. So I think this is a useful reform. It is consistent with the actual rule. It has been amended already at the request of the prosecutors, and I don't think it is an issue. Now, to the extent that there is a notice problem, I don't think it is the federal rule, but it might be. I don't have the federal rules with me. But if there's an amendment just to say that the defendant has to request, it might be a rule requirement, that you request notice of it. Fine, that's fine with me. You have to give notice that you're going to put in similar transactions. And if they want to say you have to request notice, that's fine. I have no problem with that. But to gut the rule by putting in bent of mind and course of conduct defeats the whole purpose of the character rule. Mr. Chairman, I've gone on too long, and I know we've gone around and around these issues, but I wanted to make those points, and I'll surely be happy to answer any questions anybody might have.
All right. Thank you, Mr. Martin. Any questions of Mr. Martin by any committee member? Thank you for your time today. Next, we have Ms. Fleming, Gwen Keys Fleming, the DA from DeKalb County.
Good afternoon, Mr.
Good afternoon. Glad to see you.
Good afternoon, members of the committee. My name is Gwen Keys Fleming, and it is my distinct honor and privilege to serve as the district attorney in the next county over in DeKalb County. I guess I get the luck of the draw. It seems as though last time I testified, I got to follow Jack, and he is a tough act to follow. But there are a few issues or things that I want to make sure the committee is aware of as they consider all things from both sides. First of all, when you talk about, I believe he was referring to lines 582, the cross-examination of the defendant, and taking out the word substantially. One of the things that I'm trying to gauge from this committee is whether they are interested in making sure that they follow the other states that have been where we are in terms of, are we going to codify our existing law or move to the federal rules. When you're talking about Rule 609, I think it's important to point out that out of the 47 states that have looked at that particular issue, 44 out of the 47, what we have requested would put us in the mainstream with those 44 states. We are not codifying a minority view. Likewise, on Rule 611, you've got 35 out of 47 states that are adopting the view that the prosecutors are asking you to take in that provision. One of the things I want to make sure that that all of you understand is the prosecutors are not here as obstructionists. We, like each and every one of you, have been elected by our constituency to make sure that we stand up for the rights of all people that are involved, victims as well as defendants, and we're trying to stay true to that. The issues that we have are things that we have seen in our course of actually being in the courtroom, doing battle on behalf of the citizens of our respective counties. And so when we make these suggestions, again, we're hoping that you take them in the spirit in which we intend them. Now, we can go round and round about the issue of bent of mind, course of conduct. I've heard someone say already that the courts are going to take that up. One of the things that we're particularly concerned about is, much like my understanding of what happened with the rape shield, Mr. Chairman, is that it was such a large issue and had the potential of really changing things, that my understanding, we said, well, we were going to handle that separately because there was so much discussion and really the potential to do some great damage. We put it off for a year. And perhaps as we look at this bent of mind discussion, because there is so much at stake, if we put it off for a year, who knows what the courts may decide over that time, rather than us or you as the legislature taking a step that is going to bind the hands of your prosecutors as we go forward and really make it more difficult for all of us to protect the citizens that we serve. I think one of the other things that concerns me about this particular bill is, again, referring back to the argument of, do we want Georgia to be in the minority, or do we want to follow the example of many other states that have gone down this road? One of the things that I'm concerned about is the rule of completeness. The way that it was, and I apologize, I do not have the advantage of having the amendments in front of me, but in effect, without addressing or adding the prosecutor's suggestions to that, we would actually be codifying the minority view. Again, I don't know if we want to be. Thank you, sir.
Sure.
I don't know that we want to be in the position that we are out of line or not taking advantage of the wisdom of several other states. And so we would ask you to look at that. And I guess I have to say, I have to commend all of the committee members that have been working on this since last year, or certainly over the summer. I know many of my state representatives that were on the committee reviewing this. And I certainly do defer to Chuck Olson to some degree. He is kind of the dean of prosecutors, if you will. But again, my responsibility as an elected official is to make sure I stand up for those that put me in this office and gave me this job. I had 2 folks from my office pour through this page for page, pour through the federal rules, and they came up with the help of the other DAs, a lot of the points that we put forth collectively previously. When I asked another member of my staff to look at it just recently as last week, she found yet another provision that we in DeKalb would take issue with, and that's the section 24-1-2, which I believe is on page 2, starting at lines 28, and very specifically down to line 46 and 47, I believe. One of the things that we are concerned with is that the current proposal expands the number of proceedings in which the rules of evidence would apply. The federal rule, which is at 1101, exempts preliminary hearings from having the federal rules apply. And while on line 46 and 47, this proposal says that it shall apply in preliminary hearings except that hearsay shall be allowed. I don't know if it's well known, but we in DeKalb County are having a very large problem.
And we did that as a way of trying to help correct that problem, Ms. Keys. I mean, for the benefit of the prosecutors, to resolve the issue about hearsay. And I'll suggest that, as I recall, this all came in as a result of the desires of the prosecuting attorneys. Now, is that something you want to take out?
No, not at all. What I'm saying is that it seems as though by not listing preliminary hearings in the earlier part of the statute, you are suggesting in a way that the standard there would be different from what you apply in search warrants and arrest warrants.
Well, I'm saying in preliminary hearings, I think the general consensus is that the normal rules of evidence do not apply. And we wanted to just clarify that by this provision here, recognizing for the benefit of the solicitors, the benefit of the prosecuting attorneys, that it's not going to be something you're held to as a standard when you're trying to have somebody's potential having been the party charged with the crime going forward with the indictments.
Well, and again, I guess what I'm trying to say is that at least on one other occasion, someone else found something new that we did not include
It was well
in the
vetted,
list.
I think, during the summer.
Well, my fear is I would hate for something this large that's going to have the impact that it's going to have.
Okay. Change brings about, the need of having sometimes sit down and study things as a way of. I didn't mean to interrupt you. Go ahead.
Well, and I agree with what you've said thus far, that yes, it does need to be studied. And obviously a lot of people have put in a great deal of time. We have done that as prosecutors to the best of our ability as well. And again, the issues that we bring up are not, I hope, are not viewed in any personal way. We are simply trying to get it to the point where this is something that will enable us to do the job that we have always done in a way that has served the citizens very well.
Yes.
And so I would ask that the committee take those things into consideration in your deliberations.
Thank you. Thank you for your comments, Ms. Keys. Mr. Head, Pat Head, DA of Cobb County.
Thank you, Mr. Chairman. I appreciate the
Yes,
opportunity.
sir. Good to see you.
I'm sorry you had to leave the subcommittee the other day, because not only myself but other members who got up did express our appreciation for all the time and effort that you had put into this bill, and we do thank you for that. What I wanted to make the members of the committee aware of, and especially those who are non-lawyers or those lawyers who perhaps don't really get involved in the business of the state bar, I've been practicing for over 30 years, but for the first 20 of those, I was not actively involved in the state bar, and I didn't know how it worked. And so when somebody came up and said the state bar supports this, I thought that meant all of them. We've got over 40,000 lawyers in the state of Georgia that are members of the 40,000 who are members of the state bar. We have 26,000 who are actually active members who reside in the state. The Board of Governors, which is the governing authority for the state bar, is made up of 156 members of the state bar, 156 lawyers. That's the Board of Governors. So when somebody says the Board of Governors have approved this and this is why the state bar is supporting it, that just happens to be the process that we follow through the Advisory Committee on Legislation, which is then presented to the Board of Governors. That only means that as many as 50 lawyers could have made the vote that would say the State Bar of Georgia supports this. 50 lawyers out of 40,000, to me, doesn't carry the weight that it should to say that the State Bar really supports this. I've done a walkthrough of my courthouse, talking to the lawyers who are in the courthouse, who are trying cases on a regular basis, and when you say they have to have been leading a sheltered life, they just don't read the Bar Journal, and they don't attend the Board of Governors meeting, and they don't know what's going on as far as the state bar itself. They haven't read this bill, and when I've showed it to them and asked them to sit down and look at it, they're concerned. And I would suggest to you that the majority of the lawyers in this state are concerned now about this happening. And I would simply ask the committee that to understand that when the DAs say they oppose it, and when the solicitors say they oppose it, that's a majority of all of them. That's not less than 1/2 of 1%, which is which the Board of Governors are. Thank you, Mr. Chairman.
Thank you, Mr. Head. I think, just to stop you, but I think we need to also, as a part of clarification, realize if this ever does get passed, it doesn't become effective until 2011. With the very thought in mind, there is going to be a process, just like we did back when I was becoming a lawyer. We adopted the Civil Practice Act. Lo and behold, what a change that was. Remember that?
I do.
I don't know if you were practicing back then, but
well, I was in law school.
we went,
I don't want to go through it again.
I know, but I didn't practice under the old demurrer system, but I still read cases dealing with demurrer systems. What in the world were we doing back then? you pick out little fly speck words, and you battle for months in court motions about the fly specking as opposed to just the body of what was a complaint being filed using civil actions. And I'm saying anytime I guess there's a undertaking which is to quote modernize, and I don't like the word modernize as a phrase, but to bring us from an old system that may be somewhat archaic up to the present time, there is a learning curve that goes with that, I'm sure. And part of what we're looking at is providing for the times needed for that learning curve.
I think that's really a good example, Mr. Chairman, about the demurrer system, because at that time, when you look at especially the case law that came in right after the Civil Practice Act was developed, there were many, many, many appeals that had to be decided by the court because there had been a substantial change in the law. All we're asking is, we don't really have a problem with changing the codification so that it matches the numbering system by the federal rules. We're concerned about a substantial change in the law. There's a way to do this and bring about the change so that we have the same numbering system so that people know where to go without substantially changing the Georgia law. That's all we're asking.
Yeah. Thank you.
Thank you.
It brings to mind my old story I tell about who's now deceased Judge Oscar Mitchell in DeKalb County. And he ran a unique court, if you ever appeared before, and we call it used to call it the sixth court, the Chancellor's Court on the sixth floor, rather, the courthouse. And a memory I had was back as a young lawyer coming into his courtroom, he used to have a Friday motions calendar. 200 lawyers would be sitting there, be cleaned out by 10:30. But he came in one morning at his 9 o'clock way, and he's grumbling and mumbling. He's holding this case in his hand. He walks up there, and it's after we passed the Civil Practice Act, about 1968, I guess. He said, I just got this decision this morning. It says they took a case where I ruled on motion for summary judgment. Found out I trying to rule facts in the case and should be ruling on the facts. Well, so if they're going to give a judge the power to make a decision based upon a motion for summary judgment, it should also include the facts. So after going through his ranting for about 5 minutes, he stopped and said, how many of y'all got motion for summary judgment? About 10 hands went up and says, denied. Solve that problem. On to the real stories here. Professor Paul Millich, I think you're the next one. We'll bring you up and talk about evidence.
Thank you, Mr. Chairman. And I thank the members of the committee. I've heard from a lot of interest groups. I'm a law professor. I don't represent any interest group. And I've been writing about Georgia evidence for 25 years. And sometimes people say, oh, you got an evidence code going up there in the legislature. You know, that must be a boring bill, a lawyer bill, a procedure bill. And it's important, I think, particularly for non-lawyers, to understand what's at stake. It's all about balance. It's essential to have balance in your rules of evidence in a criminal context. If the rules are unbalanced in favor of the criminal defendant, then there are guilty criminals that are going to get away, and the state will have failed in its job to protect the people. But by the same token, if the rules of evidence are unbalanced in the favor of the prosecution, then you increase wrongful convictions. And there is nothing worse that a state can do to an innocent citizens than to strip them of their freedom and to separate them from their families and to put them in prison with real criminals. Balance. That's what the goal is. Now, we're lucky because the federal rules of evidence are balanced. Now, you don't have to take a law professor's word for that. You can take the words of the hundreds of lawyers and judges and legal scholars who worked on the federal rules for over 7 years. debated them. You can take the words of the Supreme Court of the United States, and not once but twice carefully reviewed the federal rules of evidence and fine-tuned them before passing them on to Congress, where they were debated extensively over months in both the House and the Senate before being passed in 1975. You don't have to take my word. You can take the word of the 42 state legislatures that have passed these rules. Balance is not a partisan issue. Red and blue states pass these rules of evidence. From Minnesota to Mississippi, from Maine to Louisiana, from Oregon, South Carolina. Every state in the deep South, except Georgia, has passed these new rules of evidence. Now, if there were problems with these rules and they were unbalanced in favor of the defendant, I think we would have heard a hue and cry from prosecutors all over this country. But we haven't. Prosecutors day in and day out use these rules successfully to do their job. And they do so without unnecessarily increasing the risk of wrongful conviction of innocent citizens. Now, the prosecutors have said, well, yeah, but HB 24, it's not exactly the federal rules of evidence. There's some departures. That's correct. There are a few departures. Most of the departures from the federal rules in HB 24 were at the urging of the prosecutors. I've already previously handed out to the committee a list of many of those changes. The vast majority of changes from the federal rules to HB 24 were urged by the prosecutors. And the prosecutors also, in some of the areas where we departed from the federal rules for clarity or for other reasons, and said, no, we like the federal language better, we've gone back to the federal language, and there's some amendments to that effect still today. We have, in fact, throughout this whole process, recognized that the prosecutors have had a more input on this bill than any other interest group in the bar. And they've affected more changes than any interest group in the bar, without ultimately upsetting that balance, which is so key. So you're wondering, well, if you have these balanced rules, and you've bent over backwards to make all these changes for the prosecutors and addressed all their concerns, why are they still opposing it? I'll tell you why. There's two reasons. One you've already heard about. They want two major changes to the federal rules. Two changes that no other jurisdiction in the United States has. Number one, they want to require Georgia courts to use the bent of mind exception. An exception that is present in no other state. An exception which is quite controversial both inside and outside the state, even by our own judges. And as you've heard, even our own judges at the appellate level are looking at whether they went too far in that direction. Well, they want to change the federal rule to basically take that out of the hands of the court and write it right into the statute. They want to chisel it in stone. We won't do that because it will make the rules unbalanced. The second thing they want, they don't want the federal rule on co-conspirator exception. Now, the federal rule on co-conspirator exception is based on the same rule that's been around for nearly 300 years and is present in all 49 other states and in military courts. They want to have the most liberal pro-prosecution co-conspirator exception rule out there. Those two big changes. Now, those are two big changes. They're very favorable to prosecution. We think, well, isn't that good? Isn't it good that we favor the prosecution? Isn't it good that we make it easier for them to convict people? Well, as Justice Bleckley of the Georgia Supreme Court wrote over 100 years ago, be careful of making it too easy to convict, because you make it easier to convict those who are innocent as well. Balance. That's what it's really all about at the end of the day. We want it to be tough in a free society for prosecutors to take away the freedom of individuals. That should be difficult. It shouldn't be easy. But we're not asking the prosecutors of this state to do anything. We're not asking an Alabama prosecutor to do, a federal prosecutor, an Army prosecutor. They're all using the same rules. We're not making their job tougher than other prosecutors. We're just not making it so easy that we run a greater risk of innocent people going to jail. That's what this balance in these rules is all about. Now I want to address briefly just a couple of comments that have been made earlier. Ms. Abernathy's concerns about the interpreter rules and the changes there. Those changes were suggested and made at the instance of Chuck Olson of the Prosecuting Attorneys Council. If I remember right, he said that the Department of Human Resources no longer provided interpreters, and so that should have been, so that's simply a correction that he made. We went with what he said. As far as court-appointed experts, she also felt that that would impose additional burdens, budgetary burdens on the courts. That is not the case. What is doing there is we're providing a procedure for those instances in which court-appointed expert in a criminal case would be constitutionally required. All we're doing is telling the judge how to do that in those cases. Does not broaden the ability of a criminal defendant to get a court-appointed expert. That is still controlled by constitutional laws. The idea that we pass the new rules, we're going to have more appeals. Well, you always have appeals in criminal cases. I mean, basically, the defendant has a right to appeal, and that's you're going to, maybe the nature of the appeals might be a little different, but you're always going to have appeals. And finally, the comment about bar support. It's interesting that the hearings on this have all become really about the prosecutor's complaints, because most of the rest of the bar, yes, is very much in favor of this. I traveled across the state at the request of the president of the bar to go. I went to over 24 local bar associations and section CLE meetings and what have you. Ate a lot of rubber chicken. Kind of felt like what you guys have to do. And I talked to hundreds of members of the bar. And yes, there were a few. There were a few who said, "Oh, I don't want these new rules. I like the rules the way they are." But for every one of those, there were 10 lawyers, and I'll admit, generally the younger lawyers, who would come up to me and say, "What's taking so long? Why is Georgia one of the last in the country to consider these new rules of evidence? Why in every jurisdiction that touches the state do they have 21st century rules of evidence and we have 19th century rules of evidence?" And to them I'd say, well, talk to your local representatives, talk to the Board of Governors. So let me just finish. I've been involved with this project now for, isn't it, 6 years since I was asked to be the reporter for the Bar Study Committee. And we have worked through this process diligently to address everyone's concerns in every detail. Yes, it's a big bill, but it has been vetted on an amazing number of levels. I don't know how many times we have gone through this, both at the bar level and then at the Legislative Study Committee level, and then now here during the session. Answering individual concerns. Amendment after amendment, trying to make the language work for people, and I think we have achieved that. We have achieved that. But most important, we've achieved that without upsetting the basic balance in these rules. Because all of us have to consider at the end of the day, there but for the grace of God go I, or our spouse, or our friends, or our neighbor. In the wrong place at the wrong time, falsely accused of a crime. We owe it to the people of Georgia not only to protect them against crime, but we owe them a fair and balanced inquiry should they be wrongfully charged with a crime. That's been my job, teaching lawyers, both criminal defense attorneys and prosecutors, for 25 years. I seek that balance because I think it is essential in a free society. And so I recommend these on that basis, Mr. Chairman.
Thank you, Professor Milich. Any questions of members of the committee of Professor Milich? Appreciate your time and your comments. Next we have is Ken Wynn with the DA's Association.
Chairman, if I might, I would like Assistant District Attorney Mike Carlson to sit
Please do.
with me to assist me. Good afternoon, ladies and gentlemen. My name is Ken Wynn. I'm the Legislative Chair for the District Attorneys Association of Georgia and past President of the DA's Association. First of all, I want to thank Chairman Willett. I think Chairman Willett has been extremely concerned with prosecutors' concerns over this bill and has worked very hard with us to try to resolve concerns that we have about the bill. And I think that's a testament to his integrity, and certainly in our eyes that is beyond question. But I think that no matter what takes place, I don't know that we can adequately address the concerns that the prosecutors have with House Bill 24. I'm a licensed attorney practicing in the state of Georgia. I'm the elected district attorney for the Alcovey Judicial Circuit. My assistant DAs and I are in court on a daily basis representing the state of Georgia in offenses that have been committed against the state. Now, I've heard Professor Milich say that this really boils down to the prosecutors are the only ones who oppose this bill. And might not have used it in those words, but that's exactly what was implied. The reason that this bill is so important, or the rules of evidence are so important to prosecutors, is because more than any other segment of the state bar, prosecutors use the rules of evidence in prosecuting criminals, prosecuting those who have been charged with crimes against the state of Georgia and against victims. And that's why we're so vocally opposed to House Bill 24, because we think it does upset the balance. Prosecutors, my ethical duty and the prosecutor's ethical duty, the ethical duty of every prosecutor in the state of Georgia, in fact across the country, is not to convict, but it is to seek justice. And the state bar recognizes that prosecutors are ministers of justice. We're not merely advocates, as are the defense bar, as are members of the private bar who are paid to represent clients. Our job is to seek justice, and we think and we know that based on our experience and training, collectively as a group and as individual prosecutors, that House Bill 24 will impede that. And I don't think that's the intent of Chairman Willard. I don't think that's the intent of the study committee. I don't think that that's the intent of anyone with regard to House Bill 24. But as we all know, with any piece of legislation, there are unintended consequences. And I think that House Bill 24 is full of unintended consequences. We do want balance. My worst nightmare is the prosecution of one who is wrongfully charged with a crime. And that would keep me awake at night more than a not guilty verdict in a case where I know the evidence is overwhelming and the defendant walks out of the courtroom and the victim is calling me to find out what went wrong and why is the defendant walking out of the courtroom. Having said that, let me state some general concerns with the bill. First of all, is that this bill is not the federal rules of evidence. This bill is not the bill that's been adopted by 42 other states. This bill is a unique hybrid of the federal rules, of Georgia law, and some conjoining of the two. And because of that, as I stated at subcommittee, I think that there are issues that are going to be raised if this bill is passed and signed into law. There will be issues raised that nobody knows how to deal with because we can't rely fully on federal precedent. We can't rely fully on Georgia law as it exists today. We're walking into a land of uncertainty with regard to House Bill 24. That brings into play budgetary concerns. We talk about caseloads, but the work of the public defenders, the work of the prosecutors is not merely caseload, but it's workload. Our caseload won't be increased by this, but our workload certainly will be increased by the passage of this bill, because we're going to have to spend more time researching issues that are going to be raised by this bill. We're going to have to spend more time writing briefs. I understand there's a bill pending before the legislature to increase the filing fees from $80 to $300 per case. That certainly is going to drive up the cost of the local level for prosecuting appeals on behalf of criminal defendants. The public defenders are going to be duty-bound to identify all of these issues, and if they don't identify them properly, they're going to be called ineffective. And I'm afraid that that's a burden that nobody should have to bear. Chairman Willard and I have talked on multiple occasions about House Bill 24 in an effort to try to resolve concerns about this, and as I said, that we can't come to those concerns. At one point, I thought that we could. I honestly thought that we could. But I took some time and I read through the bill again, and as District Attorney Keith Fleming has told the committee, just as someone in her office identified further concerns about the bill, I was able to identify further concerns about the bill, aside from those that I had put in writing before the subcommittee on behalf of the District Attorneys Association. And let me tell you that study committee was composed of people a lot smarter than I am. But I know from working with the rules of evidence on a day-to-day basis that there are problems with the bill that are as yet unidentified. I think it's noteworthy that Mr. Martin stands up here or sits before this committee and identifies only two problems, and those two problems are with amendments that are designed to address prosecutors' concerns. I think that speaks volumes about the way that this bill will sway rights gains by victims with the Criminal Justice Reform Act of 2005. That the defense bar has no problem with House Bill 24. The only thing that they have problems with are the amendments that are designed to address prosecutors' concerns about House Bill 24. And that silence, I think, is deafening. The reason that they won't address those concerns, or the reason they have no concerns about the bill is because any departures from the federal rules, any departures from current Georgia law, are departures that are designed to benefit the defendant at the expense of crime victims. For instance, I've heard it said that the rules are 98% of the federal, or House Bill 24 is 98% of the federal rules and 2% of some other, whether it's Georgia law or some hybrid of the two. But ladies and gentlemen, that 2% is an enormous 2%. You can sink an aircraft carrier in less than 2% of the ocean, and I would compare this bill to the ocean, to the Atlantic Ocean. For instance, looking at 24-1103 on page 3, and I'm not working with the committee substitute. I don't have the committee substitute, and I apologize, Mr. Chairman.
Yes, we can get you one if you need it.
Okay, but we are talking really about 24-1103
Yes, sir.
2, the last sentence of that paragraph. 24-1103A2, the last sentence of that. That is Georgia law. It's contained in OCGA section 24-9-70. Thank you, Diane. But that's a departure from the federal rules. It is a departure from the federal rules that is designed to benefit the defendant. And the effect of that is to allow the defendant to object to evidence, and if the evidence comes in anyway, the defendant can then put in evidence in that regard. And I'm not saying that's necessarily a bad thing, but that's just illustrative of the fact that the defense bar has no problem with this.
But that is, you said, current Georgia law.
It's current Georgia law.
That's what we were doing from the study committee, correct?
That's correct. That's
Okay.
correct. Let me take a moment to find where we're at on the committee substitute, and I'll use that. Okay, thank you. Second, 24-1103D is the federal rule. It is known as a plain error rule. Well, currently there is no plain error rule in the Georgia Code, but again, that's a departure from Georgia law. But it's a part of the federal rules which benefits the criminal defendant. Let me explain the plain error rule. Current Georgia policy requires that any attorney raise an objection at the proper time, stating the specific ground of the objection to the admissibility of evidence or to some error in the trial proceeding. The reason for that rule and the sound current Georgia policy behind that is, one, good lawyering. Is to require lawyers to be on their toes and not fall asleep during the trial to the benefit, so that their clients are not prejudiced in any way by ineffective assistance of counsel. But two, is to correct errors as early in the process as possible. We want to correct errors at the trial level. We don't want to have error built into a case only to have some appellate court reverse that decision and then it comes back for retrial later on. That's a waste of resources. Well, the plain error rule, I think, is a temptation to create what I would call sloppy lawyering, to allow attorneys to fall asleep at the wheel during the course of a trial and then want to allege plain error on appeal later on. And the bar's comments recognize that, I think. With respect to 24-1103D and the state bar's own comments, they state that subsection D modifies current Georgia practice, which does not embrace a general plain error rule except in capital cases or when the trial judge comments on the evidence. And they decided one case which seems to apply the plain error rule in a non-capital case. Now, here's a little bit of what I think is a disingenuous statement in the bar's comments. It says the subsection does not purport to enlarge the grounds for appeal or weaken the policy requiring litigants to preserve errors at the trial level, but it does give appellate courts the power to reverse a judgment tainted by manifest error so substantial the court feels compelled to act even though the error was not properly preserved at trial. Despite the bar's comments, I think it does broaden grounds for appeal because it will allow defendants later on to be able to allege plain error. Judge, even though my lawyer didn't raise this at trial level, didn't object to it, we think that it's so plain that it should have been raised at the trial level. 24-1104A was a concern. It says that preliminary questions concerning the qualification of a person to be a witness or the admissibility of evidence The existence of a privilege or the admissibility of evidence shall be determined by the court subject to the provisions of subsection B of this code section. It says that the court shall not be bound by the rules of evidence except those with respect to privilege. And that's a little concerning, a little disconcerting, because it seems to allow affidavits to be submitted in motions hearings, such as a motion to suppress hearing on a criminal case. If you were to have an officer makes a stop late at night on a car, and there are 4 occupants of the car, the driver ultimately is charged with a possession offense or some other offense, DUI or something of that nature, it would seem to allow the driver of that car who's facing charges to submit affidavits from the 3 other occupants to contradict the word of the police officer who testifies at the motion to suppress hearing as to the officer's conduct or something that occurred in the traffic stop. That's hearsay. And they could do so without impunity, without being subject to cross-examination, without being impeached with any prior criminal record that they might have. That's something that I picked up on after taking a couple of days to read through the bill, and I think that was a problem that had not been identified earlier. 24.1.104C. Hearings on the admissibility of confessions shall in all cases be conducted out of the hearing of the jury. That's current Georgia law. Hearings on other preliminary matters should be conducted out of the hearing of the jury when the interest of justice require or when an accused is a witness and requests a hearing outside the presence of the jury. That is a matter, I think, that, again, is to the benefit of the defendant. He can sort of dictate what takes place in front of the jury and what takes place outside of the jury. 24.1.106 at the bottom of page 4 of the committee substitute is a departure from the federal rule that benefits the defendant. In the second sentence of that, the first sentence of that subsection or that section is the federal rule, but the second sentence is a departure from the federal rule. The last 2 sentences are departures from the federal rule. Those benefit the criminal defendant. And this is the rule of completeness, I think, that District Attorney Keys Fleming had addressed earlier. The second sentence says that evidence that qualifies for admission under this code section shall be admissible, notwithstanding that it otherwise would be admissible under the rules of evidence, except those with respect to privileges, unless the court determines the probative value is substantially outweighed by the danger of unfair prejudice. Now, prosecutors don't have privileges. We have no privileged information. Defendants do. Communications between them and their attorneys are privileged. So it creates, I think, an opportunity for there to be correspondence to a privileged, someone to whom the privilege exists, such as a psychiatrist. The defendant can make self-serving statements to a psychiatrist or to his minister in writing or in some other fashion. The self-serving parts of that privileged document can come in, but the privileged parts of that document cannot come in. That's a departure from the federal rules that benefits the criminal defendant. 24.4.404B, the similar transaction statute that seems to have drawn so much fire throughout the course of the subcommittee hearings as well as here today. It also drew, I think, a lot of attention during the study committee process. And let me say this about the study committee process. We do appreciate Chairman Willard's inviting the prosecutors to participate in that, and I know that Chuck Olson participated in that. I attended several of those committee hearings, as did Mr. Fortner and other prosecutors, but I know as well that comments that were made or changes that were suggested by Mr. Olson were changes that where the committee would not go along, the study committee would not go along with the full recommendation of the prosecutors, but we had to have sort of a fallback position. Now, I would point the committee's attention to the language in line 230 on page 8, where it talks about the purposes for which similar transactions evidence may be admitted. The including but not limited to language was language, I think, that was suggested by the prosecutors when the committee would not, the study committee would not include been of mind in course of conduct. And so we said, would you at least put including but not limited to in there? And that was an effort, and our thinking at the time is that that might not exclude been of mind in course of conduct. But I think that the Wade decision probably does. Taking the Wade decision and taking section 24 1 2412E. 24.1-2E says, except as modified by statute, the common law as expounded by Georgia court shall continue to be applied to the admission and exclusion of evidence and to procedures at trial. Well, I think 404B is a modification of current Georgia law such that it's going to wipe out benign and course of conduct with respect to similar transactions evidence. The Wade decision, I think, also, especially when read in light of the Wade decision, again, that is a departure from current Georgia law that benefits the defendant. And I heard Mr. Martin tell the committee these amendments, these two amendments that they're opposing, amendments that were designed to address prosecutors' concerns, were major departures from Georgia law. Well, ladies and gentlemen, I'm here to tell you that there are so many provisions of House Bill 24 that are major departures from Georgia law, that's that ocean that we're talking about. It's the Atlantic Ocean. That unbalances the balance that we achieved in 2005 with the Criminal Justice Reform Act. This bill is not balanced, and I respect Professor Millich, and I respect the time that he's had to put into this, but I'm a practicing attorney. I don't have time to study all 50 jurisdictions in the federal system to determine how we match up with that. Mr. Carlson has had an opportunity, I think, to survey those. And I think it would be interesting if we could hear from some other law professors in that regard. There are 5 law schools in Georgia. I think it would be interesting if we could hear from them as to how these bills this bill matches up with the other jurisdictions in the country regarding the rules of evidence. But we don't have that here today, but we'll try to do the best we can.
Do we know that they're opposed to it?
I'm sorry, Mr. Chairman?
Do we know that they may be opposed to it?
I can't state with certainty that they might be opposed to it. I think some probably favor the federal rules over this bill. I think some probably favor the federal rules over current Georgia law.
I'd be happy to have them come in if they would like to address the committee. I've heard that comment. I'm asking several times from prosecuting attorneys. I'm wondering, is there something out there that we don't know about from other people who are trained in teaching of law and certainly the rules of evidence?
I think they might be able to offer some enlightenment. I'll certainly be glad to make some phone calls in that regard. I sure will. The other problem that I picked up on with regard to Section 404, and this is in the federal rules, but again, it is a departure from current Georgia law, and that is the use of the word person in line 229. It says that evidence of other crimes, wrongs, or acts shall not be admissible to prove the character of a person in order to show action in conformity therewith. It may be offered, however, for those purposes, and it requires the prosecution to provide reasonable notice. I don't know if that means that the defense can use similar transaction against a victim. It says the word person. Current Georgia law makes it clear, I think, that similar transactions evidence is offered against a criminal defendant as long as the prosecution does it so for an appropriate purpose and can make the required showing under Williams versus the state.
Yeah, I think what we use in the federal is of the alleged victim as opposed to of a person.
Alleged person or alleged victim?
I think victim is of the accused. Character offered by an accused. Accused. My mistake. Accused, not victim.
Another departure from the federal rule with respect to 404B is that the federal rule requires the defense to ask for this notice of similar transactions. Current Georgia law does not, but again, where we want to depart from the federal rules is to the benefit of the defendant. Where we want to depart from Georgia law or retain certain parts of Georgia law is to the benefit of the defendant. I've heard Mr. Head argue at subcommittee, Mr. Bubba Head, not Mr. Pat Head, but Mr. Bubba Head, who is a noted and very competent, very well-known DUI defense lawyer, that the reason that we're allowing similar transactions evidence in the sex crimes over in 414, 413 is that those are specific intent crimes. Well, there's a multitude of other crimes in Georgia law that are specific intent crimes. That means that those are crimes that are done with a specific intent. Forgery is done without authority and with the intent to defraud. That's a specific intent crime. Burglary is the entry into a residence or the building of another with the intent to commit a theft or a felony therein. Aggravated assault is an assault done with the intent to place fear into someone.
Intent's in here.
Possession with intent to distribute. I'm responding
Yeah.
to an argument that was made with regard to specific intent. The reason they say that you should allow similar transactions evidence for whatever purpose, including bent of mind, course of conduct, and the sex crimes, is because those are specific intent crimes. Well, forgery, all the theft crimes, burglaries, possession with intent to distribute, those are all specific intent crimes. So if you're going to allow it in Section 414 of this bill and 413 of this bill with respect to sex crimes, why not allow it as similar, as bent of mind and course of conduct evidence to prove those particular crimes? Section 24.405 allows opinion evidence, and I believe that is consistent with the federal rule, but it's a departure from current Georgia law. Current Georgia law allows allows character evidence only with regard to reputation for truthfulness, not the opinion of the individual witness, because it opens the door for 25 witnesses to come in and say, in my opinion, this police officer is a liar. And you can have every family member of the defendant do that. You can have every criminal defendant in the community come in and do that. Section 24.606. That's over on page 17 of the committee substitute. Current Georgia law allows testimony to sustain a verdict, testimony from a juror or an affidavit from a juror to sustain a verdict, but not to impeach a verdict. And I think the rule for that is to, and the sound policy decision behind that is to prevent the harassment of jurors. And this happens most often in death penalty cases where the defendant is sentenced to death. New attorneys for the defendant then come in representing him on appeal or in a habeas, will go and track down the jurors who served in that case and obtain affidavits from them. We've had this happen in my circuit where an investigator went and tried to get jurors to sign an affidavit saying that was not my verdict in the jury room, or to try to impeach the verdict. And the jurors came in and testified, no, the investigator tried to get me to sign that, but I told him that wasn't the truth. And yeah, that was my verdict in the jury room. So I think that's the reason behind current Georgia laws, to prevent harassment of jurors who give up days of their time, days from their lives to come into court and serve the criminal justice system. I think current Georgia law is designed to protect them in that regard from harassment. But 24.606 is a departure from that and seems to indicate that affidavits may be used or testimony may be used to impeach the verdict as well. 24.609 requires an increased threshold to impeach a criminal defendant. That is in direct opposition, or that is contrary to the practice in 44 other states. In 44 other states that have adopted some measure of the federal rules, the defendant is held to the same standard with regard to impeachment by criminal conviction as other witnesses are. And again, this is a departure that benefits the criminal defendant. 24.612 regards witness refreshing recollection by a witness. Currently, under Georgia law, if a witness uses a writing, let's say a police officer, for instance, to refresh his recollection as to what happened during the traffic stop, if he reads it and then takes the stand, if he reads it on the stand, the defense attorney can see that report. The way the Section B is written of 24.612 on page 20 of the committee substitute, the defense could see a report anytime that report was used by the officer to refresh his recollection, so that if I have a motion to suppress coming up next week in my circuit, and I get the officer in tomorrow to review the case file and review all the reports in my case file so that he can be adequately prepared to testify truthfully as to what happened, the defense attorney can then review my file, or can review the reports that the officer looked at to refresh his recollection for that motion to suppress next week. That's contrary to what current Georgia law. Under current, and this is a change, a departure from the federal rule, which benefits the defendant. It also circumvents the Discovery Act, the Reciprocal Discovery Act that was passed back in the 1990s, and that act requires the state to turn over basically its file, most of its file, to the defense if the defense requests it. but it's sort of a two-edged sword for the defense in that they incur then the obligation to turn over parts of their file to the state, to the prosecution. This I think would circumvent that. I know that there's an amendment, a proposed
Several
amendment.
things, Rob, we're having reviewed with probable amendments to it.
Let me suggest, Mr. Chairman, that I don't think the amendment adequately addresses that concern. In that the amendment, I'm looking at AM 290805, line 19, says that if a witness uses a writing to refresh his or her memory before testifying at trial, and the court in its discretion determines it is necessary in the interest of justice, an adverse party shall be entitled to have the writing produced at trial, to inspect it, to cross-examine the witness, and to introduce in evidence those portions of such writing which relate to the testimony of the witness. What does before testifying at trial mean? There's no time limit in there. And I think the law currently is that once the jury's been sworn. And I don't think that adequately addresses the state's concern with regard to that. And I was handed a copy of the proposed amendments here today, and I've not had a chance to study them in detail, so I can't address it. I did look at that one in particular because 612 was something that had caught my attention back during the study committee process. And I think District Attorney Head did propose a change to that section, if I understand correctly and if I remember correctly, to require that this would apply after indictment or the filing of an accusation. But again, that was one of those compromise suggestions that the district attorneys made or the prosecutors made to the committee when our concern was not met fully. And then finally, Section 801 deals with co-conspirator statements. Currently, Georgia law does not require the admission or require, let me start over. Under current Georgia law, the statements made by a co-conspirator are admissible against a defendant until the conspiracy has come to an end. This places an added burden of the state proving that the statement was made in furtherance of the conspiracy. So, if you had a murder and 3 people were involved and you had to sever them out for trial so that you wind up trying only one defendant, and you have a murder, and after the murder, the 3 defendants or the 3 co-conspirators go to a buddy's home, and in the presence of the buddy, 2 of them are making statements about what happened. Maybe they're laughing about how the victim reacted when shown the gun or something of that nature, just describing that in detail. 2 of the co-conspirators are making statements regarding that in the presence of the other defendant. And the other defendant's the one that you have on trial. Well, I think under this, the co-conspirator's statements about what happened would not be admissible in the trial of the defendant that you're trying. Because they're no longer made in furtherance of the conspiracy. The murder had already happened, and they're made, I think, so they wouldn't be made in furtherance of the conspiracy and would not be admissible. I think that's a critical piece of evidence that House Bill 24 would exclude. I appreciate the time to address the committee. I know that I've probably rambled on a good bit, and I will stand for questions or stay for questions if the committee has any.
Thank you, sir. Any questions of District Attorney Wynn? Apparently not. Thank you for your
Thank you, Mr. Chairman.
testimony.
And again, we appreciate your work. Thank you.
Appreciate it, too. We have Mr. John Babcock. Mr. Babcock, please come forward. So, yeah, try to. Run the amendments and see what happens. Thank you, Mr. Babcock. Would you tell us who you're representing, please, sir?
Yes, sir, Mr. Chairman. My name is John Babcock, and I represent the Christian Science churches here in the state of Georgia. And I want to thank you, in the midst of all these distinguished district attorneys and judges who are here, that the fact that this bill does look at it, something that's very important to me and to all of the religious people in the state of Georgia, and that is privileged communication between a parishioner and their priest, minister, clergy, Christian Science practitioner. And I had submitted amendments before in requesting that the words Christian Science practitioner be included in section 24-5-502 of the bill in order to include very specifically the Christian Science practitioner. And if I may, I'd like to give a little bit of background, of my own background, to help you understand where I'm coming from. I spent 22 years on active duty as a chaplain for the United States Army. So as a chaplain, I spoke to many soldiers and family members about issues that were very important to them in very critical times. And one thing that was drilled into me very specifically was the fact that sacred communication or privileged communication is not something that resides in the clergy, but the control of that really needs to rely and does rely with the person, the penitent, the person who's taking that information to the clergy as an expression of their religion. So this bill, whereas it talks about the clergy, what it's really doing is protecting the religious expression of people, anybody who goes to a clergyman, and to protect that information, whether they're going to their priest for absolution, or they're going to their minister for guidance, for spiritual guidance, or whether they're going for healing. It's a very basic thing to protect that religious expression. Now, in specifically talking about Christian Science is similar and it's different than a lot of other denominations. What makes it different or unique is that Christian Science is a totally lay denomination. We have no ordained clergy. So in that perspective, let me tell you a little bit about how the church is organized. We do not have one individual who does everything like a minister would, conducts sacraments, conducts worship services, does counseling. In our particular denomination, we have individuals who conduct worship services, but they are elected out of the congregation, and they are totally lay individuals. So the Christian Science practitioner is set aside and identified as an individual who a person goes to specifically for spiritual guidance, spiritual care, and for healing. And that individual does not conduct worship services, does not conduct sacraments. So it's a very unique position within a religious organization. So I guess my concern is in looking at this amendment, and I really appreciate the subcommittee's consideration of this issue and trying to really expand the idea of privileged communication. But my concern is that when you look at the current bill, where it talks about Greek Orthodox priests, Catholic priests, ministers of the faith, those are all ordained individuals, ordained clergy. And if I may quickly go here to the committee substitute, and I really appreciate the fact that they expanded that to include or similar functionary. But my concern is that when it gets down to the application or the interpretation of this law, how is it going to be interpreted? And I'm backed by people who do this back there, but is it going to be looked at and saying, well, these are all listed individuals who are ordained clergy within their own denominations. So therefore, if they know something about Christian Science, and I've traveled the state and talked to a lot of people in a lot of different locations, Christian Science is not really that well known. So my concern is, when they say similar functionary, does that mean just ordained clergy? Or is it going to be applied to denominations like my own, where the clergy are not, or the individuals are not ordained, but yet fulfill that function where an individual would go to them and expecting that privileged communication?
Thank you.
So that's my concern. Now, you asked, I think, the first person who testified if they can name another state that includes the provision they were looking at. I can only name 5 if you want, but that's only 5 out of many that include the words Christian Science practitioners in their evidence codes.
Right. Okay, thank you. And that was something I think came out as part of your testimony before the subcommittee was, and that was included, or a similar functionary, correct?
Well, that was part of what we included, but I think that's important to have that in there. But we'd like to have, after Rabbi, Christian Science practitioner or a similar function.
Thank you, sir. Any questions of Mr. Babcock this time? Now we thank you for your time. And I have last Mr. Tom Byrne, if you will please come forward and address the committee. Mr. Byrne has served on the State Bar Committee. He's currently serving, I believe, as president of the Evidence Code or Evidence Committee, and worked very diligently with the study committee for the entire summer. I don't think you missed a meeting, if I remember correctly.
I think I just missed one, Mr. Chairman. There were so many of them, I can't remember how many at some point in time, but there were many, many people, as you recounted, who were at those meetings, and there were many others who were at the involved in the state bar process, which preceded the meetings this summer. And many of those lawyers were not members of the Board of Governors, and yet they were involved in the process of coming up with a good and balanced bill, we thought. And the Board of Governors, of course, are not philosopher kings. They are actually supposed to be representative, and we hope in most cases are, of the 26,000 or so Georgia lawyers who would be involved in use of the rules of evidence. And I must say, in my experience, talking with lawyers throughout the state about this project, I have never had a reaction from a lawyer to the idea of adopting the federal rules of evidence that did not begin with something like, finally. I mean, we are so far beyond the rest of the country in modernizing our evidence rules that it's embarrassing. I'll give you one date, 1863. Now, if you know your history, you know that was the date. That was the year of the Emancipation Proclamation. It was the year of the Battle of Vicksburg, and it was the year in which most of the Georgia evidence statutes were first enacted. We are in desperate need of modernization of Georgia evidence law. I don't think, and I'd like to ask Professor Milich, yield some of my time to him to respond to a few specific points, if that's permitted, but I don't think it's a great idea to make policy and oppose a piece of legislation like this simply because the criminal defense lawyers have not been sufficiently vocal in opposing it. I think I would urge the committee to look at the merits of the bill, and indeed I think you'll find that this is good policy with a true reform bill with few costs attached. So if permissible, Mr. Chairman, I'd like to yield the balance of the time you would allow me. I'm going to allow that.
What I'm going to do, Mr. Byrne, because we have a number of committee members. I'm afraid we'll start losing people. I want to have everybody here to go through the debate of it. Certainly, if the committee members want to ask of Professor Milich questions, I'll permit that. But let's just go ahead and let you provide your statement to us.
Let me wrap up then. I was very much heartened to hear D.A. Keyes Fleming and D.A. Head and others, and I have no doubts about the good faith of the prosecutors who have been involved in this process today and really from the beginning, that they are not intending to be obstructionistic and are not against the idea of modernizing the evidence code. I think that may be the basis for some, I hope, compromise that would allow this important legislation to go forward and improve Georgia law for all the lawyers and judges who count on using evidence rules and the evidence code every day.
Thank you so much. Thank you. Any questions, Mr. Byrne? If not, you appreciate your being with us today. And let me just comment on the issue about the bar. We've had a standing policy, as long as I've been aware of it, as far as this committee, Judiciary Committee and the legislature, not taking up matters that are supposed to be bar issues unless it has gone through the Board of Governors, because we recognize that as being the governing body of our state bar. So the only reason that's brought up is the fact that we only acknowledge the fact that the state bar, through its governing body, has endorsed the program, or the proposal rather, of a rewrite of the evidence code. And with that said, I don't think we have anyone else. I want to close off. If there's someone else has something they feel is important to state to the committee, please say so. Otherwise, we'll close off the public input, and it now will be in the breast of the committee for consideration. I'll first ask for discussion among committee members. Do we have any discussion? I think one point of discussion we do have, if there's adoption, motion to adopt, rather, we have a number of proposed amendments. A number of these were adopted from last week, again trying to address a number of concerns that were brought to us. These were brought by District Attorney Paul Howard, which we have not heard from, but Mr. Howard and I met, and he had several things which I believe also address concerns that we've heard from various other prosecuting attorneys. So we've prepared some proposed amendments addressing these concerns. And if there's not any discussion among the committee members, I will entertain motions at this time. Do we have a motion?
Do pass, Mr. Chairman.
Second.
Motion made and seconded of do pass. Any proposed amendments? And I want to ask at this time, I'm going to recognize our legal counsel, Jill Travis from Legislative Council, to address with us the various amendments. Ms. Travis, and why don't you take in whatever order you think is best and easiest way to present the proposed amendments, and we talk about them. Let me get you, there you are.
Alrighty.
Thank you.
I'm going to start with least controversial, AM 290792. That is,
Yes.
it's a 3-page document, and all it is doing is adding what you see in the italicized language. In other words, we added catch lines to the,
Correct.
this is the hearsay exception. So all of the italics language on the various 3 pages is what's new, so that reference to the hearsay exceptions are a little easier to find if they were codified.
Let's talk about that one first as we go through them. Might, and that was done at several people's suggestion, because it does help when you're doing research in that large section of the proposed code, to allow you to go down, read down, and find what may be by the heading that particular area that will address issues you want to look into. Any discussions regarding proposed amendment 29-0792? Second. Moved and seconded. Any further discussion on the motion? If not, the motion to adopt is called for. All those in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Your next proposal, Ms. Travis.
AM 290806. This is an amendment that deals with the court being able to call its own witness. It's page 21 of the bill. This was a matter that was brought up by Mr. Potter, and Mr. Clark also from the GTLA worked on it. There was some input from the prosecuting attorneys with respect to being able to call witnesses in criminal cases. And what this does basically is carve out that, you know, the judges can't call any witness unless it's suggested by the parties, but the court could be allowed to call a court-appointed expert, a witness regarding competency, or a child witness, and would of course always be able to interrogate the witness. That's on lines 9 and 10.
Right. And
so it's a change to Rule 614.
Change in Rule 614, and I'll state that I believe we pretty much follow what is either recognized by law or case law with respect to the court having the ability to call on other witnesses without really the language being here. We're recognizing what is pretty much a ongoing right a juror has, a court has rather, to do this. Now, who's got your mic push? You mic push?
I did, Mr. Chairman.
Okay, I recognize Mr. Jacobs.
Ms. Travis, I don't believe we had discussed the court-appointed expert language at the last committee meeting. Where did that
The
come
good
from?
professor pointed out, I think it's in 706.
Okay.
Rule 706 in here allows the court to call its own witness.
Okay.
And so this was consistency.
Okay.
Further discussion? Do we have a motion on AM 290806?
Second.
Moved and seconded, do pass. Any further discussion on the motion to amend? If not, Chair will call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Next, I'm going to go to AM 290803. and that is an amendment to Rule 103, which is on page 3 of the bill. And basically it removes a good bit of the language on lines 74 through 77. That language reflected is actually current law 24-9-70, but the prosecutors have had some objection to that continuing language, so this is an effort to remove that language from the bill.
So it read now on taking out the line.
Line 74 would end at the word appeal, and the
Appeal, there we go.
rest of the text to the end of line 77 would be
Right.
removed.
So the sentence, if on direct examination of a witness objection is made to the admissibility of evidence, neither cross-examination of the witness on the same subject matter nor the introduction of evidence on the same subject matter shall constitute a waiver of the objection made on direct examination. That is the section that would be removed.
Yes, and that is, I believe, currently 24-9-70.
Thank you. So we have that as current law.
Yes, sir.
And as for comments, discussion among the committee members. Chair will open to a motion. Motion made and seconded. Do pass. Any discussion on the motion? If not, the chair will call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Ayes carry.
Next is AM 290804. This is an amendment to Rule 106 on page 4 of your committee substitute. And this, the federal rule is reflected in line 113 through 116. And there was additional matter that was added on lines 116 through 122. This strikes the language, and this is one of the objections that the prosecutors had raised, wanting to have that language removed from Rule 106.
All right, discussion among the committee. Anybody have questions regarding what is proposed by the amendment? Have you had a chance to read and digest it? No questions. The chair will call for a motion. Been moved and do pass and seconded. As far as amendment AM 290804. Any discussion on the motion? Now the chair will call for the question. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
The last amendment is AM 290805. Mr. Chairman, would you like me to take those individually?
Let's do. I want to go through each one of them. We'll talk about them as a specific amendment.
Okay. The first one, lines 1 through 4, is an amendment to Rule 402, which is on page 7 of your bill. And the specific amendment, or the specific issue that the prosecutors were raising, was having to do with rules applicable in particular courts. And so this language was added as the rules prescribed pursuant to constitutional or statutory authority applicable in the court. So in other words, it would have to be in the state court, it would have to be a rule that was passed by the Supreme Court in the state court rules, or if it was a workers' comp matter, it'd have to be done by statutory authority. So it's a rule applicable in a particular court.
The concern there would be courts being renegades, adopting some other rules of their own as to how things to be done, and being sure that doesn't happen, to only have rules that are appropriately adopted by the state Supreme Court, or as you mentioned, the Workers' Comp Board. Any discussion, questions of members of the committee? No discussion. Chair will call for a motion.
Second.
Moved and seconded, do pass. Any further discussion on the motion? The motion to amend is as to the First Amendment, and we'll number these as the first one being amendment to 24-402. Call for question. All in favor signify by saying aye.
Aye.
Opposed, like sign. The motion carries.
The next one is an amendment to Rule 404, which is on page 8. And if you'll look on your bill on line 231, what the amendment does is it, first of all, I'm looking at the on page 8. It strikes the language, if the probative value of admitting such evidence outweighs the danger of unfair prejudice. It takes out that phrase. And then it then goes on to take out other language that the prosecutors didn't like about the 10-day notice, and just says that the prosecutors have to provide reasonable notice in advance of trial unless excused by the court on good cause shown. And then it goes on to adopt other language that the prosecutors wanted, that the notice wouldn't be required when evidence is offered and circumstances surrounding the charged crime, motive, or prior difficulties between the accused and the alleged victim. So it's modification to Rule 404B.
Thank you. And I think we also have the time frame is addressed by Superior Court rules and
Yes,
state
sir.
court rules. So there's not really a need to have in here just recognize what may be otherwise reasonable. And that's something for the court to address with the means of introduction of that testimony. Then the court can decide whether or not there's been appropriate notice given by the one party to the other, correct? I think
Yes,
you're
sir.
right.
I just
Thank
spilled
you.
water all over myself.
That's all right.
That one.
Any discussion among committee members? If not, the chair will entertain a motion. Motion do pass as to the amendment to 24-4-404, which is the second one on 290805. Call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Looking at line 13 of the amendment, if you'll move your pages to page 19 of the bill, this is in Rule 609, and it takes out the word substantially on line 582 at the top of the page. The word substantially does not appear in the federal rule.
Right. Get my right page, excuse me.
Page 19.
Yeah. 582. I'm sorry. Here we go. And I believe we got a question by Ms. Oliver.
Ms. Travis may know this history. Was this subject to some earlier compromises in some earlier years in relation?
It was.
And so this is a change of the law that related to compromise that was set forth in '05?
I believe so.
Okay.
And that was going out of what we'd heard earlier as being the omnibus bill that we had dealing with criminal law that year.
Yes, sir.
Came through non-jury, I believe. I mean, non-jury, non-civil judiciary. Any comments on your part, former chairman?
I'm sure it was an excellent piece of work.
As far as keeping it or losing it or anything of that nature? I think you're the one working as far as the negotiation between the parties.
In a prior year?
In '05, yes, sir. I don't know if you recall back then what was going on. I wouldn't either. Just giving you an opportunity to comment if you had any. If not, we can move on with the.
Let's move on.
Let's move on. Do we have a motion as to the third amendment, which is the amendment to section 24-6-609 at line 582? I hear no motion. It will die for lack of a motion to amend. Next we have
The next one is to Rule 611 on page 20. And if you look at lines 631 through 634, it removes that language in its entirety and substitutes exactly the federal rule, which is limiting cross-examination to direct.
So where we heard, we're departing from federal rules, this is putting exactly the rule that is in the federal rule in its stead, correct?
Correct.
Word for word. Ms. Oliver.
And this does change the existing Georgia law.
Yes.
And
we don't have it statutorily, I do not believe.
But you believe it's the existing Georgia law that we're changing?
Yes.
Okay. And consistency-wise, and during the summer, we were trying not to do that.
All right. The position was during the summer that study committee did not have the ability, I felt, to do policy change this particular body does, as being the Judiciary Committee of the House. So if we're doing anything, that's where we're recognizing the proposal as being something appropriate as a change what we have as far as statutory language on this point.
Current law 24-9-64 is the right of cross-examination that says the right of a thorough and sifting cross-examination belong to every party as to the witness called against him. If several parties to the same case have distinct interests, each may exercise this right. There's actually, with respect to 611, there are 4 current code sections that fall in the genre of creating 611, and that would be 24-9-62, treatment of witnesses, 24-9-64, which I just read, 24-9-63, when leading questions are allowed generally in the discretion of the court, and then 24-9-81, impeachment of a witness by any party and the right to call and examine and impeach the opposite party. That's what the bar looked at, in addition to the federal rule 611 when they created what you see before you in 611.
So they compiled all of those into what is 611 A, B, and C.
Yes, sir.
We're now just saying as to Section B, if there's to be an amendment, we look at the federal rule as being a type of language to be inserted there. Correct?
That's the proposal.
Okay. Any further discussion among committee members? If not, the chair will entertain a motion. The move do pass. Is there a second? There being no second, the motion fails for lack of a second.
The next one is in relation to Rule 612, which is on the same page. You're on page 20. And what it does is, this is the one, this is having to do with refreshing the recollection of a witness. And Mr. Wynn was correct that the language that appears on line 64 and 644 and 645 was the language the prosecutor suggested, that in criminal proceedings after indictment or the filing of an accusation or similar charging document. That was the summer study committee compromise. The language that you see before you makes it more clear that it's only testimony at a trial. It takes out the language at the beginning of that sentence with respect to in criminal cases, the filing of an indictment or similar charging document. There's various edits through 644 and 651, 652 rather, but the main issue is that it takes out the word hearing and applies the refreshed recollection to the issue of a trial.
Correct. Any questions of Ms. Travis as to this particular amendment, which is amendment to 24-6-612? Any discussion? If not, the chair will entertain a motion.
Move do pass.
We have a motion do pass on 612. Is there a second? Second. Motion made and second. Any discussion on the motion? If not, the chair will call for a vote on this amendment, 612. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries.
The next amendment is to Rule 801, which is on page 30 of your bill. And what it does is it takes out basically lines 988 and 989. In other words, just what you see on 987 would remain.
So it would stop at belief in its truth, period.
Correct. The silence
the next
and
port,
it's all
next
taken
phrase
out.
there, including a party's acquiescence or silence when the circumstances require an answer, denial, or other conduct, which I think has been current position as far as Georgia law, has it not? Somewhat. I remember you always use silence as a potential omission.
Yes, that is current law.
Thank you. Any discussion on the amendment to 24-8-801. Any questions of Ms. Travis regarding that? Does everyone understand the motion? We are striking, in effect, the last phrase beginning on line 988 and ending at, there's more to it, I'm sorry. 988 and 89. Yeah, 988 and 989. No further discussion. Chair will call for a motion.
Do pass, Mr. Chairman.
Motion do pass. Is there a second? Motion is seconded. Any discussion on the motion? Not, the chair will call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion passes.
The next
Then-
amendment is to 24-13-134, which is going to be on page 78 of your bill. And this actually, what you see on page 78 is current law verbatim. This had to do with the depositions in criminal cases.
Yeah.
And the objection that the prosecutors were making was that it was not party neutral, and the amendment makes this party neutral.
So the discussion there was that we were looking at the ability of either the prosecutor or the accused in deposition making available documents used for purposes of preparation at that deposition. So it goes
Correct.
both ways. As before, it's just as to the accused had the right, correct?
That's correct.
Does everyone understand that motion or that discussion? Any questions of Ms. Travis or discussion on the provision? If not, the chair will call for a motion on 24-13-134 as stated in the proposed amendment. Got a motion do pass. Is there a second? Motion made and seconded. Any discussion on the motion? Not, chair will call for a vote on the motion. All in favor of the motion signify by saying aye.
Aye.
No, opposed, like sign. That motion carries. Is that all the motion? I mean, all the proposed amendments?
Yes, sir.
I want to bring to your attention, at least for being aware of what we talked about earlier as far as an effective date as prepared in this bill. It shows for, if you go over to page 128.
129.
129, I'm sorry. 127, 129, there we are. Section 97. We have placed the effective date of the bill to be January 1, 2011. And I may say, of course, as we've had in the past, where we've had major rewrites of provisions of our code, and I use the CPA again as an example. I think we changed that 3 or 4 times before it finally became effective. And but this is putting a target date out there, at least to have an opportunity for everyone going through classes, do our reading they need to become familiar, the use, application of the rules. And you might also explain, for the benefit of the committee, Ms. Travis, the other provisions that we have, Section 70, et cetera.
Well, we did it not only an effective date of 2011, but make it applicable to motions or hearings and trials commenced after that date. So if you were in the middle of a trial and at the end of December, the old rules of evidence would continue to apply, or a hearing, etc. And then Section 70 of the bill, which is one of the cross-references, has a contingent funding provision with it, and that's why the sort of awkward language is on 435 through 4357.
Do we have any questions among committee members regarding the matter of the effective date? Yes, sir. Mr. Bruce.
Does this not give this the effect then of if anyone has further challenges, we got 2 more sessions?
Yes, sir. Yes, sir. Anything that comes up that somebody says, this has come through, it doesn't look like it's workable, there's also the opportunity before the effective date becomes applicable to revisit and look at that.
You did that in the child support.
That's a good point. Another recent legislation we did. Any further questions regarding the matter of the effective date? Does the committee have any questions, any further amendments? If not, the chair will call for a motion on HB 24 by 20, it's LC 293737S as amended by committee. as a substitute. Have a move to pass. Do we have a second? Been moved and seconded. Any discussion on the motion? If not, the chair will call for a vote on the motion. All in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
The chair is in doubt. The chair will call for a show of hands. All those in favor signify by showing your right hand. Count as 9. All opposed to the motion signify by raising your right hand. 4 opposed. Motion carries. Let me say in closing, as far as the process, this has been a very long process. I appreciate very much the time and efforts, especially of Ms. Travis. I can't begin to thank her enough for what she has put into this project for the last 6-7 months. And on behalf of myself and the committee, Ms. Travis, we are most grateful for your hard work with this matter. And I'm sorry we got groups that may not feel it's appropriate. I think that what I'm understanding and my belief is, as we look at this as lawyers, first of all, this has been a needed modernization of what we have as far as our way of approaching evidence. The thing I found from my own years of practice, a lot of what we have in evidence, especially dealing with documentary and testimony, evolved from back at a time when we didn't have what we do today as far as the discovery. I'm speaking now civil side of it primarily. But so much of what we did as far as the rules of evidence evolved from a time when there was not discovery. And I see today that because we do have discovery, so much is done as far as documents, electronically, etc. There's been a great need for modernization of these rules, and certainly the federal rules as a model code has been an appropriate one to use as our guide. And I appreciate the State Bar Committee's work on this too, and we'll go forward with this point and see how the matter travels through the remainder of the General Assembly. If there's no further business, the committee is adjourned.